Mr. Sullivan, if in the event your client needs to take money out of the joint account to acquire, as far as the money down on a vehicle, that Miss Logan would be entitled to receive an equal amount as a withdrawal as well.
Yep, no objection.
Okay, go ahead, Mr. Todd. You can prepare that and you can proceed with your other motion.
Thank you, Your Honor. In terms of the, probably makes sense to start with the house. Miss Logan is currently pregnant. She's in a high-risk pregnancy because she had a prior cesarean section and is a diabetic. So the stress changes in her cortisol levels, which can cause changes in her sugar levels, and this can actually have a significantly negative impact on the fetus in terms of issues with the heart.
Yeah, I got July 1st. I'm feeling all right. Baby is good. That was July 1st.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2024-19860M, Allison Logan versus Andrew Logan. Today is Monday, September 3rd, 2024 at 9:04 a.m.
Court will note the appearance of Mr. Todd on behalf of the plaintiff, Mr. Sullivan on behalf of the defendant. This matter is before the court on the two motions of the plaintiff, a motion for temporary parenting time, custody, exclusive use, and possession, and a motion for a mutual temporary restraining order concerning assets. Mr. Todd.
Thank you, Your Honor. Your Honor, I'll start with the mutual restraining order. I've read Mr. Sullivan's response, and the reason we requested the mutual restraining order in part is that the opposing party was spending $250 to $300 at party stores, which became approximately $1,000 a month. She requested this stop, and it didn't at that point. The parties created individuals' accounts. In May, he moved $12,000 from the joint account into his bank account, and then she moved $12,000 into her individual account as well. Prior to speaking with an attorney, she then moved $130,000 into her saving account. She is totally fine putting back $118,000 into the joint account, which is the just less than $12,000. So she's totally fine moving that $118,000 into the joint account as long as the mutual restraining order is in place. Currently, there is $52,000 in the joint account. Additionally, in relation to the response, she's transferring money into the joint account. She's transferring half of the amount that it would be for the bills into the joint account. So we do believe that it's appropriate that the mutual restraining order exists. And if that happens, my client is certainly happy to, again, return that $118,000 back to the joint account. And do you want me to go into the other motion too as well?
Well, let's have Mr. Sullivan respond. Mr. Sullivan, you've heard Mr. Todd. Does that resolve issues on the, I guess, preliminary injunction?
A couple of points. First of all, Mr. Todd begins with the assertion that my client was spending X amount of money at a liquor store, and that was the basis for filing the petition for ex parte order. As he was saying that, I reviewed the ex parte motion, and there's nothing in the motion that suggests that at all. So that seems to be a curious statement today when it wasn't pled initially. And
okay, well, let's get past that because I didn't grant the ex parte anyway, Mr. Sullivan.
Well, fair enough, but I don't see that ever has been presented as a basis, and it's hard to respond to that when it just comes up this morning.
Okay.
Secondly, we don't have an objection to the issuance of a mutual restraining order. What we would like to see is an accounting by each side that can be done in connection with the filing of the domestic financial information form that indicates who withdraw what amount of money at what time. So that's what we would ask for. I don't think we're apart on this issue.
Okay,
No objection, Your Honor.
okay. Court will grant a preliminary injunction at this time, enjoining the parties from disposing of, secreting, I guess you'd say, in any way hindering their various assets. Court would allow, as Mr. Todd has suggested, that the plaintiff would transfer $118,000 back into the joint account, and then would you be able, Mr. Todd, your client, be able to account for those withdrawals, et cetera, within 30 days, let's say?
Your Honor, I guess if we could have 45 days just to be on the safe side.
Okay. Mr. Sullivan, would your client be able to comply within 45 days?
Yes, and
Okay.
yes, Your Honor. I
Okay.
did have one thing to add. And I've communicated with Mr. Todd about this issue, but my client is in the process of ending a lease on a truck. He's going to need to have another truck. My plan is to work with Mr. Todd on that, and perhaps if necessary, enter a consent order to allow for him to get a different truck. And if that necessitates some jockeying of money, then we'll make that work, Your Honor. Would you agree, Mr. Todd?
Why don't we just do that, Mr. Sullivan, if in the event your client needs to take money out of the joint account to acquire, as far as the money down on a vehicle, that Ms. Logan would be entitled to receive an equal amount as a withdrawal as well.
Yep, no objection.
Okay, go ahead, Mr. Todd. You can prepare that and you can proceed with your other motion.
Thank you, Your Honor. In terms of probably makes sense to start with the house. Miss Logan is currently pregnant. She's in a high-risk pregnancy because she had a prior cesarean section and is a diabetic. So the stress changes in her cortisol levels, which can cause changes in her sugar levels, and this can actually have a significantly negative impact on the fetus in terms of issues with the heart. We've attached some verification as an offer of proof to our motion. And so the physician actually recommended that Mr. Logan move out of the house. Additionally, Miss Logan cannot live with her parents. They have 4 dogs and she has 3 dogs, or they have 3 dogs. Unfortunately, that's simply not feasible. However, Mr. Logan has another house in town that he owns. And additionally, his parents also live in town, so he could live with them as well. So we are respectfully requesting exclusive use and possession of the home be granted to Miss Logan. And I'm happy to continue forward if you want with my custody portion.
Yep, go ahead.
Thank you. In terms of custody, Miss Logan has always done she's been the primary caregiver. She has done all the drop-offs for the minor children's school or daycare and has absolutely been the primary caregiver. Mr. Logan has a substantial history of alcohol abuse. Upon returning home from work at 7 or 8, he will usually start drinking. That unfortunately has continued even since he has been served with this motion. Even within the past few months, he went to a high school reunion and passed out in his car. His parents needed to pick him up. This is just an indication of how the alcoholism has continued. Additionally, he does have an OWI in his history. Mr. Logan's work schedule, in essence, prevents him from being able to parent a 2-year-old child, just turned 3, and anything more than the County standard parenting time, we don't believe would be anything he could actually even use. He was fired in April, and since that point, he has not been picking up the child. Just actually after being served this motion, he has started picking up the child once in a while. But again, Miss Logan has always been the person who has picked up the child, with the exception of always been the one who dropped off the child and has picked up the child with the exception of a few weeks. It is accurate that Mr. Logan plays with the child, but unfortunately, that's all he does. He does not bathe the child. He does not provide the child food. He doesn't do anything like that. He does not take the child to appointments or schedule appointments or anything of that nature. Additionally, in relation to the response, the alleged reason for the breakdown is not just an attraction issue. That is one reason, but the reason for the breakdown is unfortunately Mr. Logan's alcohol addiction, and additionally, he has been cheating on her and unfaithful, and that's the reason for the breakdown. Additionally, unfortunately, relatively recently, Mr. Logan's parents were watching the child, and then upon drop off to Miss Logan's house, they berated Miss Logan about the divorce in front of the child. So we are respectfully requesting that the court remind everybody to not have any discussion in front of the child. So we are respectfully requesting that Miss Logan or Mr. Logan have the Calhoun County Standard Parenting Time provided for children from 3 years old until entry of kindergarten. We did change this from our original request because the child did turn 3. So we are respectfully requesting the court order that, and we would request that midweek visit just be once a week on Wednesday. Lastly, we did include in our motion that Mr. Logan's brother not have contact with the minor child because he does have he is on the central registry for CSC.
Okay, thank you. Mr. Sullivan?
A lot to respond to, Judge. I want to start out with the presumption under law, and the presumption is that joint custody is presumed to be in the best interest of the minor child. My client's position is that the parties have equally provided joint care of the minor child. My client's position is backed up by testimony that should we have a hearing, would offer the paternal grandparents say that the care was equal between the two of them. And I've, as indicated in my pleadings, Judge, my client did work at Semco until just recently. When working at Semco, he always provided the pickup, the care after school or after daycare, and the care in the evening, early evening part particularly, and then they joint cared in the evening. So the care was equal, if not more, in favor of my client. So for the plaintiff to assert otherwise and simply focus on who took the child to daycare at the beginning, ignoring all the afternoon and early evening time and then the joint care in the evening, is disingenuous and is mischaracterization of the facts. Again, joint custody is presumed. They're still together. They still have equally co-parented. And for that reason, that shouldn't change simply because Miss Logan wants a divorce. It is in the best interest of the child to continue to be in equal care of both parents. Now I want to talk about this claim of the drinking. There were two assertions in the motion filed by plaintiff. One was that my client had a OWI of sorts in his history. That's true. But as I've indicated in our response, Judge, that was 14 years ago, 12 years before Wyatt was born. To suggest that that has any relevance to today's action is just illogical. Secondly, today, Mr. Todd asserted that he consumed too much at a reunion. That's not accurate. There was a union meeting as pled in their motion. He did consume too much alcohol in April of 24. He did the right thing and didn't drive home. To suggest that one occasion of consuming too much alcohol is a reason to not award joint legal custody to two parents who have equally co-parented is, again, illogical. The plaintiff makes a number of allegations, none of which is supported by other than what the plaintiff alleges. We, on the other hand, allege the opposite, and they've lived together since the child was born, and they've equally co-parented. We're asking that you issue a joint physical custody order. Wanted to mention about the ailment that is alleged by plaintiff. We have text messages wherein plaintiff texted to paternal grandmother that, this is a bit of an oddity, but plaintiff will not communicate with my client about the pregnancy and the prenatal care. She will, however, communicate with paternal grandmother And she did just recently communicate that all things are going well in the pregnancy. So that's not consistent with the assertion that there's a stress level that's impactful at the present, because it's not, as affirmed by Ms. Logan. So we're asking that my client retain the home, that my client have joint physical custody of the minor child.
Okay, thank you. Mr. Todd, any response?
Just very briefly, Your Honor, my apologies, that was a union issue. However, he, in essence, told my client and the child he was going to return home that night. And he failed to do so, drinking excessively, to the extent that he passed out in his vehicle. Again, just indicating how significant the alcoholism problem is. Additionally, he will continue to drink after he returns home, which is not until 7 or 8 o'clock at night. So we believe it's absolutely relevant. In terms of my client's pregnancy, the closer this comes to fruition, the more important it is to remain her A1C levels to remain intact. And her indication to the opposing party's mother that pregnancy is going okay, that's because she's trying to manage these levels as much as possible. But again, we have a physician note requesting, in essence, that she be given exclusive use and possession of home.
Okay,
Nothing
well,
further, Your
Mr.
Honor.
Todd, as you might know, court doesn't consider the physician's recommendations as to exclusive use of the home, so.
Yep, I understand, Your Honor.
Okay. Well, what the court's going to do is the parties still are together in the home, so the court is going to, at this point, the court is going to grant to the parties the joint physical and joint legal custody of the minor child. The court will, at the time that the parties do separate, the court will put in place a parenting time of a 2-2-3 schedule for the parties. Court will order support consistent with the that schedule when the parties have separated. And in this matter, the court will, at this point, is based upon what is stated. The court doesn't believe it's appropriate that the parties continue to remain together. In this matter, the court will grant to the plaintiff the exclusive use of the home and order that the defendant would vacate in 45 days from today's date. Court would order that when the parties have the child in their particular care, that they would not consume any alcohol. So, sir, at this point, there's just been allegations, and that's all they are at this point. But I will let you know that, again, should it come up that there is drinking when, again, you have the child in your care, that the court could utilize that as a basis to, in fact, make a change in the custody and parenting time. So, Mr. Todd, I'll have you prepare that order, submit under 7-day notice of entry.
Thank you, Your Honor. I apologize, Your Honor. Just one question. Mr. Logan's brother is.
Oh, yes, I did. I wanted to address that. I didn't.
Okay.
I'd place that his brother, Justin Mark Logan, would not have any contact with the child. So, sir, I understand that you may have some issues, but if you're at your house or at your parents' house and the brother comes along, you have to leave, because I don't want him having any contact with the child. Okay, thank you. You can include that, Mr. Todd.
Thank you, Your Honor.
Okay, have a good day.
Thank you.
Attorney Todd, I'm gonna call your next case.
Okay.